Hello, today's topic of discussion is Wagering Agreement. Introduction. According to Section 30, agreements by way of wager are void and no suit shall be brought for recovering anything alleged to be won on any wager. A wager means a bet, that is gambling. The subject matter of bet may be anything. A wagering contract is described to be a contract by which two persons professing to hold opposite views touching the issue of future uncertain event mutually agree that depending on the determination of that event one shall win from the other and the other shall pay or hand over to him a sum of money or other stake. For example, A and B agrees with each other that if it rains on Sunday, A will pay rupees 100 to B, and if it does not rain on Sunday, B will pay A rupees 100. Such an agreement is a wagering agreement and hence wagering agreement is void. In wagering agreement, neither of the contracting parties having any other interest in that contract, then the sum or the amount or stake he will so win or lose. Parties to wagering contract focus mainly on the profit, that is gain or loss they earn. If agreements enter into between parties under the condition that money is payable by A party to the B party on the happening of a future uncertain event and B party to the A party when the event does not happen, are called wagering agreements or wager. There should be a mutual chance of gain or loss in wagering agreement. A wager has been defined as a contract by A to pay money to B on the happening of a given event in consideration of B paying to him money on the event not happening. Sir William Anson's definition of wageries as a promise to give money's worth upon determination for a certain moment of an uncertain event. To constitute a wager, the parties must contemplate that they must accept the determination of uncertain event as the sole condition of their contract. The event may be one which might or might not happen or may be sure to happen, though no one knows when it will happen. Again, it need not be an event to happen in the future, but it may be a present or even it may be a past event, the reason of which is unknown to the contracting parties or they are unaware of the event when it will be happen. So that is the reason, for example, that is the election result of election held the previous day at a distant place, or again about an event which is certain but regarding which there is uncertainty in the mind of contracting parties. For example, if the parties bet the height of a well-known building or as to who was the Prime Minister of India in 1962. So for this also they can have wagering agreement or betting agreement. So here the event may be past, present or future. Let us discuss the essence of wager. Essence of wager. The essence of gambling and wagering is that one party is to win and the other to lose upon a future event, which at the time of the contract is of an uncertain nature. That is to say that if the event turns out one way, A will lose, but if turns out the other way, B will win. It is essential to a wagering contract that each party may either win or lose. Whether he will win or lose being dependent on the issue of the event and therefore remaining uncertain until that issue is known if either of the parties may win but cannot lose or may lose but cannot win. It is not a wagering contract. Let us discuss the essentials of wagering agreement. So following are the basic essentials of a wagering agreement. The first essential is it must be dependent on an uncertain event. One of the important essentials of a wagering agreement is that it must depend upon an uncertain event. Event may be past, present or future, that already we have discussed, but the parties must be unaware of its future or the time of its result is unknown or the time of its happening is unknown or unaware or there is uncertainty in the mind of contracting party. So it must be dependent on an uncertain event. For example, a football match between Team A and Team B is to start at Wembley on 30th July 2020. R and S enter into an agreement that R will pay rupees 500 to S if Team A wins, and if Team B wins, S will pay rupees 500 to R. So this is wagering agreement and is void. Second essential is mutual chance of gain or profit or loss. Another element of wagering agreement is that each party to the agreement should stand to win or lose as per the result of the uncertain event. Example, a cricket match is to start at Calcutta between India and Australia. If India wins the match, A agrees to pay B rupees 5,000. Whereas if Australia wins the match, B agrees to pay rupees 5,000 to B. This is a wagering agreement. In this case, each party has the chance to win or lose. Here, the gain of one party will be the loss of the other and vice versa. The gain of one party must be the loss of the other party. Third essential, no other interest in the event. Neither party should have any interest in happening or non-happening of the event other than the sum or amount or stake he will win or lose. If either party has some other interest other than the sum he will win or lose, it will no longer be a wager. A contract of insurance without insurance interest will be nothing more but a pure gambling or wagering contract and shall be void. In other words, if the insured has no insurance interest in the subject matter, the agreement is a wager. Example, A, the owner of a house insures his house against fire with GIC. A has to pay an insurance premium of rupees 500 per month as per the terms of the contract. If the house is destroyed by fire, GIC will pay the actual amount of loss suffered by him. Here, A has interest in his house, means here he has insurable interest in his house. Further, on the happening of the event, that is fire, A will not gain anything. Hence, it is not a wager. So, insurance contract are not wagering agreement. Number 4, fourth essential is no control over the event. The parties to the contract should not have any control over the happening of the event, one way or the other. If one party has the events in his hands, means if he has control over the event, the transaction will not be a wager. For example, X and Y entered into an agreement that if X resigns his job, Y will pay rupees 500 to X and X will pay rupees 500 to Y if he does not resign his job. Here, X has the event under his control. That is, X has control over his resignation and hence it is not a wager. So, in case of wager, one of the essential is that the parties to an agreement should not have control over the event. Number fifth essential is promise to pay money or money's worth. The wagering agreement must contain a promise to pay money or money's worth. So let us discuss exceptions, that is what are not wagers. The following transactions are not considered to be wagers. Number 1, contract of insurance are not wagers, as we have previously discussed that the insurance contracts are not wagering agreements. A contract of insurance resembles or the contract of insurance are similar to wagering agreements, but they are really transactions of a different character. Insurance contracts are contracts of indemnity. It is a contract of speculation. It is based on an uncertain future event. They are entered into to safeguard the interests of one party to the contract. In this contract, the insured has insurable interest in the property or life. Hence, it is not a wager. But in wagering contract, there is no insurable interest. Distinction between wagering agreement and contract of insurance. So let us discuss the difference between wagering agreement and contract of insurance. An insurance contract differs from a wager in the following respects. Number 1, in a wagering agreement there is no insurable interest, whereas a contract of insurance has insurable interest. Second, wagering agreement is a void agreement, whereas a contract of insurance is a valid one. In a wagering agreement, neither party has any interest in the happening or non-happening of an event. But in insurance agreement, both the parties are interested in the subject matter. Fourth, wagering agreements are conditional contracts, whereas insurance agreements are contracts of indemnity, except life insurance contracts, which are contingent contracts. Number 5, the object of wagering contract is to speculate for money or money's worth, whereas an insurance contract is to protect an interest. Number 6, a wagering agreement is just a gamble, whereas a contract of insurance is based on scientific and actuarial calculation of risks. Second is, games of skill competitions are not wager. Skill plays a substantial part for the successful solution of certain competitions. For example, crosswords competitions, pictures, puzzles, athletic competitions, etc. Here, the puzzles are awarded as per the merit of the solution. Such competitions are not wagers. However, if prizes depend upon a chance, that is a lottery and therefore a wager. Example, a crossword puzzle was given in newspaper and it was stated in the newspaper that whose solution of the crossword puzzle would correspond with the solution kept with the editor, he would be given the first prize. So this is a game of chance and therefore a lottery and thus is a wager. Further, as per law, the prize competition involving games of skill are not wagers, but if the amount of prize exceeds certain amount, they will be regarded as gambling and therefore they are void. Because in case of skill competition, the skill of a person or intelligence of a person is involved, and therefore in many cases such competitions are not covered under wager. Number third, horse race competition is not wager. State government may authorize the horse race competition if it is permitted by the local laws. In such cases, any subscription or contribution of the value of rupees 500 or upwards made towards any prize or sum of money which is to be awarded to the winner of any horse race shall not be unlawful. In other words, agreements to subscribe or contribute towards such prize or sum of money is also valid and enforceable. Example, A entered into an agreement with the race course authority who was permitted to conduct the race course competition to contribute rupees 600 towards the money which was to be paid to the winner of the horse race to be held on a particular day. This is not a wager. Number fourth is share market transaction are not wagers. Transactions for the purchase and sale of shares and stocks with an intention to take and give delivery of shares is not a wager. However, if the intention is only to settle the price difference, the transaction is a wager and hence it is void. Number fifth, sports competitions are not wagers. Sports competitions such as athletics, wrestling, indoor games, boxing, football, cricket, hockey, etc. are not games of chance. It is decided by skill and intelligence and hence they are not wagers. Now let us discuss effects of wagering agreements. In India, wagering agreements have been expressly declared to be void. So, it cannot be enforced in any court of law. Section 30 of Act states that agreements by way of wager are void and no suit shall be brought for recovering anything alleged to be won on any wager or entrusted to any person to abide by the result of any game or other uncertain event on which any wager is made. As a matter of fact, though wagering agreement is void and unenforceable, but it is not forbidden by law. That is, the wagering agreements are void but are not illegal. However, in the state of Gujarat and Maharashtra, the wagering agreements have been declared to be illegal. As far as collateral transactions are concerned, as the wagering agreements are void but not illegal, they are not void. Therefore, they are enforceable. For example, where a person lends money to another person to enable him to pay off a gambling debt, the lender can recover the money so paid. So, reference for this article, the references which I have taken. Number one, Principles of Law of Contract by Praful Desai, and other one is Wagering Agreement and its Essential by Shrishti Chawla. So here I have completed Wagering Agreement. Thank you.